The Honorable Eric J. Eisbach, Judge, presiding. All persons having business before this court drawn near, give attention and you will be heard. May God save the United States of America, the state of Florida, and this honorable court. Please be seated.
Good morning. Welcome to an oral argument session of the 5th District Court of Appeal. I'm Judge Eisnagel. On my right is Judge Boatwright. My left is Judge McIver. We're the panel this morning for one case, 23-2502, Levy versus Deerwood Place. Is that correct? That's our case. All right. So for the appellant, if you'll let me know how much time you'd like to reserve for rebuttal. Oh, over here. Okay.
Yes, sir. If you'd like us to switch.
It doesn't matter. Normally this is the appellee, but really doesn't matter at all. So
5 minutes, but if I use my whole 15, we'll first go around on each.
well, each side will have 20 minutes. I'll attempt to help you remember on the 5 minutes, but ultimately it's your responsibility to watch that. I'll try to help you. And so each side will have up to 20 minutes. Your intent is to reserve 5 for rebuttal. That's fine. And so, counsel, whenever you're ready.
I do have one question.
Sure.
The court punted the motion to dismiss. Are we to address those issues in our argument about the briefs, or is...
You can, and the court may or may not have questions about it.
Okay.
And so you may proceed just whenever you're ready.
Good morning, and may it please the court. David Wayner on behalf of appellants, Dr. Levy and his wife, Nuna Levy. I'd like to start out by identifying a mistake that your honors have probably caught in our brief on page 8. There is a case that we quote and identify with an ID, but we did not give the cite to the case. I alerted opposing counsel, I believe last Friday, to this, and I apologize for the mistake. It is mine because we copied and pasted out of our motion for summary judgment. But the case that quotes the Pepe v. Whispering Sands case is the Woodside Village Condo Association v. Johnson, 806 Southern 2nd, 452, Florida Supreme Court, 2002. Again, that's my mistake, and I apologize. The trial court erred in interpreting the declaration in this case, and that error resulted in a judgment for the appellee, and that judgment should be reversed with directions to enter judgment on behalf of my clients, the appellants. Pursuant to the Woodside and the Whispering Sands cases, as I'm sure this court is aware, the declaration of a condominium is its constitution.
Did your client sold the condo at issue, correct?
They did.
Okay. So why is this appeal now not moot?
It is not moot because of the collateral, actually 2 reasons, I believe, but the primary one is the collateral legal consequence of attorney fees at the trial court level.
Were they ordered below?
Yes, sir.
How much?
Well, the court reserved the jurisdiction to do it. The appellees filed their motion, and then when I sent discovery on that motion to determine how much they were going to seek, the court stayed that pending this appeal. So that issue is still out. The final judgment of fees has not been entered, but their entitlement to fees does not. Is out there.
Entitlement was granted, but he hasn't determined it.
Correct.
The judge hasn't determined an amount yet.
Correct. Yes, Your Honor. And so, again, in our response to the motion to dismiss, I cited the Godwin case, which the Florida Supreme Court said that if there are collateral legal consequences that accompany the case, then it is not moot.
Is it your position that there's, moving along to the merits of the case, is it your position that there's an ambiguity or that there is not an ambiguity?
There is not an ambiguity. In fact, you're anticipating the next point. 3 times in the final judgment, at page 10, page 12, and again on page 12. The final judgment refers to the declaration as, quote, unambiguous, the unambiguous language of the declaration.
You agree with that?
Yes, sir, I do. Absolutely. And consistent with that, the trial court in the final judgment does not identify an ambiguity that it needs to resolve, which again, I would agree is proper. Yet despite not finding an ambiguity, stating there is no ambiguity, the final judgment cites and relies on evidence. If you look at paragraphs.
To be clear, it says that it's unambiguous in favor of your opponent.
It is, what it says is it's unambiguous, and then it cites evidence to interpret the declaration, and I'll demonstrate that.
Yeah, what evidence is that used to interpret the declaration?
The short of it is you cannot find that the closet in question is a mechanical room without looking at extrinsic evidence.
Is mechanical room defined in the declaration?
Mechanical room is not defined in the declaration, and
Why is it error then not to take testimony on that issue?
because the floor plan was unambiguous. The unambiguous key says that the common elements, the limited common elements, and the association property are going to be marked with crosshatches or some other thing.
Exterior walls are also common elements on that floor plan, correct?
That would be true, but it's a floor plan, not a wall plan, respectfully. And so, the fact that the closet does not have the crosshatching on it, it is unambiguously part of my. It is unambiguously.
So, is the
I'm sorry.
I mean, is the testimony about whether it's a mechanical room or not? Was that testimony used to determine what the statute, what the contract means, or was that evidence used to determine whether the contract, whether ultimately, the contract is clear, or the declaration is clear that a mechanical room would not, your client would not own that, right? If it's a mechanical room.
A mechanical room by the language used in the declaration.
So is that improper extrinsic evidence then to interpret the contract itself, or is that just a fact? And if it is, then why is there not a latent ambiguity?
First of all, I believe that, the court didn't find that it was ambiguous. Again, 3 times it says.
Well, it doesn't matter what the court thought, right? It's a question of law, right? So we could determine that it's ambiguous and disagree with the trial court, right? So again, why is that improper extrinsic evidence? And even if it is, then why isn't this a latent ambiguity that would allow, by the way, extrinsic evidence to come in, correct?
I believe it would, yes. But in this particular case, again, the declaration is, let's go to Volusia, Aberdeen, and Raines. Specific provisions of a contract govern over general provisions. Every single provision cited by the appellees is a general provision. The specific provision, the floor plans, the graphic descriptions, which are just as much of the declaration as any other part of the declaration, are clearly show that closet does not belong to the association.
Because it doesn't have the marks.
Because it does not have the
But
hash
so
marks.
is it your position that your opposing party was not proper to introduce testimony concerning the square footage of the unit? Isn't that extrinsic evidence under your definition?
It is. It is absolutely extrinsic.
So how would any court ever determine whether the square footage, as shown in the declaration, matches up with the unit without that testimony, without somebody coming in and saying, "Hey, I went and looked, I measured. Here's the actual square footage of the unit in there."
Okay, and that's fair. And the fact that you're asking it means.
But isn't this an important discussion for your argument, though, right?
Not for my argument, because the square footage didn't match up. I mean, the first DCA, this is the Shores of Pan Club, which
No, for your extrinsic evidence argument, I'm talking about why is that improper extrinsic evidence?
because The court did not find, based on the square footage, that the closet did not belong to my clients. Sorry, what the court did was the court looked at photographs showing that there are common elements within the closet, which, as we pointed out in our reply brief, the declaration deals with that. The declaration says, in the event that there is an encroachment by a common element on a unit or by a unit on a common element, there shall exist an easement in favor of that encroachment. So the declaration is kind of a catch-all that's put in the declaration to address this very issue. And that's why we suggested to the court at the end of trial, and that's why we put it in our briefs, that the correct way of deciding this is at the time of the trial, the Levies owned the unit. It is part of Unit 243. And the association has an easement that's created by, I think it's Section 4.4 of the declaration, to have its stuff in there. That's what we were arguing, because that is, you're not getting outside the four corners of the declaration to find that. And again, if there's no ambiguity, you don't go outside the four corners of the document itself.
But you still have to apply the document to whatever facts are out there in the world, right? Just because there's some facts involved doesn't mean that doesn't mean that that's improper extrinsic evidence to interpret the meaning of the declaration.
But to use extrinsic evidence to determine that it is a mechanical room when it's not marked as mechanical, and I don't know if y'all caught this on our reply brief, but the floor plans for Unit A on the second floor show a mechanical room cross-hatched. So whoever the scrivener was, and there was no testimony from the scrivener at trial, they knew how to identify a mechanical room, and they knew how to cross-hatch a mechanical room, and they did it for Unit A on the second floor. They did not do it for Unit A on the floors above.
Right, I think the question here is not did they have the ability to do it or know how to do it. The question is was the failure to so indicate a scrivener's error or not, right? I mean, that's the question.
And if it was a scrivener's error, then as we argued below, and as I put in my brief, the statute of limitations has run on that. Because what effectively happened at trial was Judge Ferguson took out his pen and said, you know what, chink, 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 this is a mechanical room, and it's now common area. And according to the case law that we cited, it's...
Well, I mean, I don't know if that's right. I mean, if there's an ambiguity in the contract, then is that are we talking about the same thing then? You're talking about reformation, right?
Correct.
So you're saying that if we conclude there's an ambiguity, then aren't those two different things, reformation and resolving an ambiguity?
I don't know precisely how to respond to that, and I'm sorry, but I would
say...
Well,
are they the same or not?
They're not.
Okay.
But I believe that the result is the same. You have reformed the declaration.
So whenever a court resolves an ambiguity in a legal document, you're saying that is the same as reformation?
No, it is not. But in this particular case, because the effect of resolving that ambiguity, and this is a document that deals with real property, it's the Constitution, and you have now, in resolving the ambiguity, you've again taken out your pen and reformed the document. And the existing case law says that if the association had an issue with that, about the ownership or the use of that particular thing, that they should have brought that action within 5 years, and their failure to do so means that the floor plan is the floor plan. There's no cross-hatching there. It unambiguously belongs to my client, and if you apply this,
What about the fact that the declarations talk about the boundaries of the unit, and the boundaries of the unit are from the interior walls in? You would agree with that the declaration states that, correct?
The declaration does state that.
So isn't this closet, though, outside of those boundaries? They're outside of those exterior walls, correct?
It does not identify exterior or interior walls. That's not on the key. What the key says is everything that is cross-hatched in this floor plan is common area, limited common area, or association property.
So the thicker walls are not defined anywhere as
There
exterior
was
walls?
no testimony at all regarding that.
Tell me how your legal argument if the diagram didn't exist. It was just the words in the declaration and the amended declaration. What's your argument then that the closet belongs to your client?
I'm not sure that I ever would have brought this if the diagram didn't exist.
So your sole argument is based on the F unit floor plan?
Yeah, I mean, again, specific versus general.
Does the declaration just absolutely, if we only look at the declaration, the words in the declaration, is the closet sort of in this twilight zone that nobody knows, there's just no indication who owns it?
I believe that would be accurate, although yes, I believe that would be accurate.
So, four corners of the document notwithstanding, talk to me about the impact of the testimony that at closing, this was a question, and that Mr. Levy was informed at closing that that was not part of the property, and still continued on and closed on the property. Does that indicate to us that there was a meeting of the minds that that was not his property?
No, sir, what Dr. Levy was told was it was a Scrivener error, and he did not agree because and again, I'm
Seems to me that that would be something to resolve before closing then.
and in his mind, it was resolved before closing because he had a floor plan that says it's his.
He says it's his, they say it's theirs. Is that a meeting of the minds?
No, but it's also an issue with, I mean, he's closing with the seller of the property, not with the association. And so, whether or not he took possession, whether or not there was a meeting of the minds to take possession of and to sell Unit 243 is between him and the seller, whereas the ownership of the closet would be between him and the association.
Well, the seller didn't think that they were selling him the closet, did they?
No, but I don't know that the seller is an attorney and knows how to read a legal document. According to the statute, the unit is defined as, whatever is Unit 243 is Unit 243, and again, according to the floor plans that are attached to the declaration and incorporated into the declaration.
But ultimately, my question is, rather than resolving it at the time of closing, your client also waited 5 years.
No, sir. My client waited, I believe my client bought it in 2020.
Okay.
So, that's,
Counsel, you're into your rebuttal time. You can keep going, or you want to save it?
I'll save it. Thank you.
Counsel for the appellee, whenever you're ready, you can begin.
Thank you, Your Honor. Christopher Cobb of Jacksonville for Deerwood Place Condominium. Your Honors, we filed this motion for mootness.
But in the declaration, just the declaration. Give me your best argument. Forget the diagram for a moment. The words in the declaration, where does the closet belong? Based on the declaration and the amended declaration.
The declaration and the amended declaration, the closet belongs as a common element with ownership into the association.
That's a conclusory statement.
Okay.
Give me the argument.
Okay, so when you look at I think the fundamental question that this court should apply or ask is, what did Dr. Levy buy? And where do we look to find what he bought? And the declaration, you can't just look at the floor plan to say, oh, well, I own this or I own that, because there are items in the floor plan that are common element that are not crosshatched. For example, at the record on page 643, there's a porte-cochere that is a common element that is not crosshatched. The declaration says that structural components within the unit are common elements to be owned and maintained by the association. So when you look at the definition of boundary of the unit, and you look at the definitions of what he bought, which is a condominium parcel, and it's clearly identified, we contend that the condominium parcel consists of the unit, which is graphically depicted in Exhibit A in two places in the record, but it is also addressed by square footage and definitionally. And so when you say the airspace.
We got where we're trying to go. We're right there at the trailhead now. Now that we're at the trailhead, take us down the trail. Explain to us from there the words in the declaration and the amended declaration.
Okay.
Tell us the argument, lead us through it. Where does the closet belong?
The closet is outside of the unit. So when
No, well, who owns the closet, right?
The association.
Walk us through it. You mentioned square footage. You mentioned some things. So now we're there. We're at the trailhead. You know what trailhead is?
Yes.
Okay. Now we're at the trailhead.
Okay.
Take us down the trail.
All right, so when you walk through the definition of what is the parametrical boundaries of the unit, it is considered and defined as the airspace within the unit. And so common sense would dictate you go to the door. And this is the door of my condominium. And if I follow the parametrical boundaries defined in the declaration, I will take my hand on the right door frame and I will touch the wall all the way through the inside of that unit, and I will come to the other door jamb.
And that's based on the airspace
That's the
language.
airspace, the parametrical boundary airspace.
But
within
isn't
the
there,
unit.
don't at least some units have a separate storage closet or something like that? So that doesn't totally get us there, right? Because there is something outside of that.
Well, actually, the declaration does totally get us there because it says that there are limited common elements. And so when you look at what Mr. Levy purchased in his condominium unit, in his parcel, he has 2 balconies. Those are specifically defined as limited common elements, and those house air conditioning units that are solely for the unit. Then there's limited common element of a garage space and a limited common element of a storage space within the garage space that he is specifically assigned at closing, and that's in the declarations. There is no testimony, and I think Dr. Levy would agree, that, and certainly the testimony of Andrew Bowden, the property manager, this garage or this storage space on this floor was not assigned to him at closing. And so when you look at the parametrical boundaries, when you look at the square footage, when you look at the declaration, when you look at all of this in totality, I think we get to the point where this is not Dr. Levy's closet to convey, to own. It's not his, and he never did own it.
So now we've covered the airspace. I get it. Talk to me about the square footage issue. How can you make an argument based on square footage that the closet does not belong to the appellant?
I think, yes, outside of the vacuum. And so we're looking at all of these in the vacuum, and I don't think we can look at them in a vacuum. I think we look at them in their totality. But assuming we have square footage, the square footage of the unit was measured. Now, the declarations say it was 2,800 square foot about under the architectural measure method. When they remeasured it, it was 2,700 square feet. When Mr. Migas, I believe his name was, when he actually measured the unit, it showed that Dr. Levy had more square footage than what was reflected in the declaration.
Without the
closet.
Okay.
Correct, without the closet. The square footage is important because it does go to sort of the mootness argument where the association uses the square footage to determine the pro rata portion of assessments that you need to pay. And so if I don't think that this court respectfully can even make this decision based on the sale of the unit, because what it would be doing would be affecting property rights of those that are not parties here. So if this court were to come in and say, Dr. Levy,
the problem is you have pending. The problem is that you're pursuing attorney's fees, right? And how is that not a collateral consequence?
Well, the Kendall case says that a mere possibility of attorney's fees is not a collateral consequence. The Goodwin case that was cited dealt with a lien based on medical invoices for treatment.
The mere possibility isn't the only cases I saw, counsel, were pretty distinguishable from what we have here on mootness, right? So, in other words, you can't have a party say, well, hey, we don't have any determined right to attorney's fees yet, but gee, if we win this case a year from now, then we might get attorney's fees. That's a different ballgame than what we have here, isn't it? Here, we have the trial court has already determined an entitlement, and just the only reason there's not a judgment is the trial court hasn't determined an amount.
Right, and I think this falls in line with the 51 Island Way condominium that I provided supplemental authority for. In that case, the position was abandoned, and there's a condominium case interpreting the same statute that we're operating for our attorney's fees here. The position was abandoned by the owner right before trial. and the trial court denied the attorney's fees. It said, we agree with the parties that the case is moot, but we're denying attorney's fees, any prevailing party attorney's fees. The association took that on appeal, and the appellate court said, no, in fact, because of the voluntary act of the owner, attorney's fees are appropriate, and they reversed for an award of attorney's fees. And that was with no trial and no determination of prevailing party. Here, we have that, and so we are already the prevailing party as it relates to the final judgment. And so I think the court then went through a discussion as to whether or not it was a voluntary act or whether it was circumstances beyond the control of the unit owner. And the cases that they distinguished, one was a voluntary act, and the other one was a child. A child was living in the unit, and they said because the parents separated, the child was then removed from the unit, so the child can't control that, and so that's circumstances beyond the control here. But where you take a dismissal or where you sell the unit on the eve of oral argument, we think that that's basically a tacit a volitional act that would entitle Deerwood for appellate attorney's fees here. We're going to have, assuming that the final judgment is upheld, even if this court determines that it is in fact moot, we believe that appellate attorney's fees would be appropriate here. But going on the mootness, I don't know how this court can fashion a remedy, or any court can fashion a remedy for Dr. Levy right now. So, I mean, I would love to sit here and say, you know, affirm the judgment, but I don't even know that I can ask that.
Well, I don't know that we would, maybe there isn't a remedy, right, other than potentially, right, if we agree with appellant's arguments, reversal of the judgment, and then, you know, attorney's fees go away, and then the case is just over, because then it really is, it's moot everywhere, right, theoretically, right? So in other words, I don't know that this court necessarily has to come out and say, hey, you know, reversed and you win, right? We could just say the judgment was in error, therefore reversed, and when we remand, well, if it's moot, then it's moot, right?
Then I guess we all go away.
Right, exactly. But you said, I don't know, you just said, I don't know how we can give a remedy to the appellant, and I'm just saying, I'm not sure that, I think that there's maybe some variations there.
Well, what he's asking for is a declaration that he owns the unit, and so...
well, he might be asking for that, doesn't mean he gets it, right?
Understand. But I think, and we would contend that the sale of the unit is a problem for this court. We think that it does render the matter moot. I mean, there was no prayer for an easement. There was no prayer for reformation of the deed. It was a declaration that I own the unit. And so, if the final judgment is affirmed, I mean, we go back and we own the unit.
Can the trial court consider the testimony that, hey, look, the declaration says mechanical rooms are not part of the unit, and this is a mechanical room? Can the trial court consider that testimony, or is that improper extrinsic evidence?
I think it's proper testimony, Your Honor. I think the mechanical room is defined in the declaration as a common element. And the court is not...
There's no ambiguity about what a mechanical room is in the declaration, right? I mean, it's pretty clear, and the declaration says what it is, right?
Yes, it's a mechanical room. And mechanical rooms in associations are, again, relatively clear that they service other things other than a unit. And so if the mechanical that is in this closet was serving Mr. or Dr. Levy's unit, it would be defined as a limited common element. It is not doing that. It is serving the common element. The air conditioning handler unit in there is serving the common element. So it is serving not his property. And so to claim ownership over something that's not defined in the declaration as his and is not even exclusively used for his definition takes it out of the unit in its entirety. I don't think the court is required to abandon its common sense, and we asked for a view at the lower court, and in lieu of the view, there was photographs. And so when you walk in and look at these photographs, the court can look at this photograph and say, oh, this confirms that this is a mechanical closet. By looking at the photographs. We don't have to look at the
in other words, it's not interpreting the declaration, it's saying what the state of the world is, right? So that we can determine what the impact is from the declaration itself.
Yes, yes.
Other than the Unit F floor plan, were there other floor plans that have mechanical closets?
Other than the Unit F4 plan?
Yeah. Are there
Yes.
other floor plans? And are those shaded?
They were shaded, yes.
They are. So this is the only one that's not shaded?
That's correct.
Okay.
Do you agree that Okay, well, let me not say it that way. Was there an ambiguity here? Your position is that failing to shade this closet was a scrivener's error, correct?
We can, I don't think we pushed the scrivener's error, because if we said a scrivener's error, we would need to have the testimony of Beezer, who created these plans, to say, we didn't do this. Our contention is that the documents, when read as a whole, are clear that Dr. Levy doesn't own the unit.
Well, I mean, isn't it your position that the closet should have been shaded, right?
The closet could have been shaded, and the
No. Should have been shaded, correct? I mean, should have.
Should have.
And it wasn't.
Correct. It was not shaded.
That's why we're here, right? But it should have.
It should have.
Okay. So, is there an ambiguity here? When you look at the fact that it's not shaded in the diagram, but then you look at the language in the declaration, is there an ambiguity? Do they seem to conflict? And if not, help me out. Why?
They are different, right? They do appear on the graph as the graphical depiction, but when you read the document as a whole, the court can reconcile that difference. It can reconcile the difference with the definitions, with the square footage, with this is a mechanical closet. Mechanical closet is defined as a common element.
Would you describe that as an ambiguity?
Well, I can take one clause of a contract and read it in a vacuum. But when I look at the document as a whole,
I see what you're saying.
It's clear. I mean, and there's the three ways that you use to define the unit. You don't just look at one and say, well, I own that. It doesn't matter. A picture is only worth 1,000 words if you don't have the words.
So
We have the words.
essentially, you're saying, look, there should have been a belt and suspenders here. The declaration says what a mechanical room is and says it's not part of the unit, but also the diagram should have shaded the closet, belt and suspenders.
Belt and suspenders.
In this case, we forgot the suspenders, unfortunately, but we still have the belt.
Yes, and so my pants are still being.
And so
held.
therefore, it's not really ambiguous because the belt is still holding us up here.
Yes.
Okay.
And if there was a scrivener's error, we don't have to engage in the exercise of a reformation, because the declaration allows the board to correct scrivener's errors.
So, going back to the original trailhead that Judge Eisnagel had asked about, why does the description take precedence over, why does the belt take precedence over the suspenders? Why are we choosing the descriptive rather than what's easy to look at? When I'm buying the property, am I going to put more faith in the hundreds of words, or am I going to put more faith in the picture that is worth them?
I don't know, respectfully, when you're buying the unit, you need to look at it as a whole. I mean, certainly a non-legal trained personnel will look at the graphic depiction and they will say, oh, okay, great. That's what I own. I have that closet. But when I go to the property manager pre-closing and post-closing.
The contract is between those non-legal parties, though, right? So it needs to be understandable by them, of course, with the assistance of a legal trained mind, but still, the meeting of the minds is between the people who are engaged in the deal.
But at what point do I then get to say, well, I own this closet, and the person selling me the closet says, no, you don't, before I close, and yet I proceed to closing under that interpretation by them, and then ask for a key to my closet, of which it's refused. And now you see why we are here.
So when entering into a contract, does it matter if the person that enters into it is a lawyer or a lay person? Do we interpret the contracts differently?
I don't know. We don't. But you have to look at the document as a whole. And when you look at the document as a whole, the definitions are part of that definition of the unit, as well as the square footage, as well as the graphical depiction. And so when we have this totality review of the document, it's clear to us, and at least presented at trial, that this closet was not included within the unit. Now, there was some extrinsic evidence brought into trial so that if the judge did need to make that determination, he could, and that was the building official with the plans. That's very clear that the building official said that the plans for this construction said it on it mechanical closet. And so, it's when you define it that way, I mean, that's one of those things where are we asking the court to not look at the mechanical closet and only look at the paper? Or can the court look at the closet and say, okay, there's conduit, there's something that services anything other than your unit. This is obviously a mechanical closet. Dr. Levy, you don't own this. And so based on that, assuming that the court finds that the matter is moot, if the matter is not moot, we would ask for, if the court determines that the matter is moot, we would request attorney's fees for having to go through the exercise up until this point. If the court says, no, it's not moot and we're going to decide it on the merits, we would ask that the court find in favor and affirm the final judgment.
Thank you, counsel. All right. Counsel for appellant, looks like you have 4 minutes and 16 seconds.
Outstanding.
Whenever you're ready.
Yes, sir. Again, may it please the court. With all due respect to opposing counsel, what I heard was a lot of, we need to look at the general intent and we need to look at the whole declaration, which is exactly what the association said in Raines, which was cited by the Florida Supreme Court in Volusia v. Aberdeen. And that's what the trial court in Raines also accepted. And what the Fourth DCA in Raines, and then by extension, the Supreme Court in Volusia v. Aberdeen said, when you have specific provisions in a contract, they are going to overrule the general if there's any kind of difference between them. And in this particular case, you have the only two places in this entire declaration that deal with Unit F and this closet are those floor plans. Everything that he cited to you was general. I don't
know if saying that mechanical rooms are not part of the unit, I'm not sure that's really very general. That seems pretty specific.
I would agree with that if the mechanical rooms weren't shown on other floor plans. But in this particular case, they're shown elsewhere.
Look, whether there was a scrivener's error or not in the diagram, I'm not sure that changes the plain language in the declaration and the amended declaration saying that mechanical rooms are not part of the unit.
And I appreciate that, but the plain language of the key on the floor plan says that the common element is crosshatched, limited common element is crosshatched, and association property is crosshatched. And when you don't crosshatch it, that means it's none of those three. That's the unambiguous language of the specific that governs here. You all asked about the Scrivener error, and if you're, I think we said this in our reply brief. That was in their answer. That was in their answers to interrogatories, and they kind of abandoned that at trial again, I believe, because of the statute of limitations issue. And then opposing counsel mentioned the floor plan, sorry, the building plans, and there was testimony at trial from the City of Jacksonville building inspector. But does the law expect someone who's buying a condo to go behind the Declaration, which is the Constitution, and go ask the building department what something says? I mean, that's what they're implying there.
In this case, they also could have read the declaration, right, that said mechanical rooms are not part of the unit.
But they look at the floor plan and say, that's part of my unit.
No, but the floor plan, I mean, the floor plan isn't the superior part, right? Like, that's not the only part. I mean, there's also the declaration.
But it is part of the declaration. It's every
part of.
Right, but it's every bit as impactful as the language that is used. And
so you have a floor plan that seems to say this closet belongs to the unit. Then you have the declaration saying, hey, square footage is this, mechanical closets are not part of the unit. How's that not an ambiguity between the two?
Okay, on the square footage, I would agree that that would be an issue if they matched up. So just very basically, and I see I have 50 seconds. According to the original declaration, using method X, you should have gotten result A. And according to the amendment to the declaration, using method Y, you should have gotten result B. Those didn't match up. Using X, you didn't get A, and using Y, you didn't get B.
Did the result, was the testimony that there's more square footage in the unit than the declaration says there should be? Without the closet?
I don't remember specifically what Mr. Megas' testimony was. But all I know is that, I mean, to me it was a red herring because they didn't match up. So the only thing you can do is go back to the declaration and...
So it doesn't matter that the square footage was actually more than the declaration said?
If the square footage had matched up, it would have governed.
Okay.
Thank you.
All right, counsel, thank you. Very well argued on both sides. And with that, we are adjourned.